ThinkTech. I'm Jay Fidell. This is Keeping the World Company. Today we're going to talk about universal jurisdiction with our regular panel and a special guest from Rome, Italy, Federico Thofern. And we're going to find out how it's working in Europe and beyond. Welcome to the show, co-host Tim Apicella, regular contributor Stephanie Dalton, and our special esteemed guest from Rome, Italy, and Project Expedite Justice, Federico Thofern. Federico, let me start with you because we had this discussion in an earlier show here on ThinkTech, and I'd just like to give you a little time to familiarize our viewers with what is universal jurisdiction.
All right. So first of all, thank you for having me again on this show. It's a great pleasure to be here with you and to discuss quite important issues that are in the media these days. I'll jump right into it. When it comes to universal jurisdiction, we're looking at something that is described, first of all, as jurisdiction. So the power of the state to regulate affairs pursuant to its own laws. So this power of the state is often exercised relying on traditional heads of jurisdiction. So when can I prosecute a crime? And these traditional heads of jurisdiction would be the territoriality principle. So the crime happened on the territory of a certain state, the active or passive nationality principle. The victim was a citizen and national of the state that is now prosecuting the crime, or maybe the perpetrator, in the case of the active personality principle, was a national of the state that is now looking into the crime. Or lastly, a crime was committed even abroad that attacked and threatens fundamental values of the state. This is the protective principle, the state protective principle of jurisdiction. Everything I mentioned thus far requires some kind of linkage to the state, to a certain state. So the victim was a state national, the crime happened on the territory of the state, or the state itself, the personality of the state was involved or threatened. When we talk about universal jurisdiction, we find a certain state in a position to prosecute and adjudicate cases that do not feature any kind of linkage to said state. So the perpetrator was not a national, the victim was not a national, and the crime happened outside the borders of the state that is now looking into this certain crime, that is trying to prosecute it and adjudicate it through its courts. So universality, as the term suggests, is a way to connect the crime to a state that formally is not linked to said crime in any way, in any traditional way, one might say. So when do we talk about universality? When is universality actually important? When does it actually play a key role? It is relevant when we look at international crimes, at international core crimes. So the gravest of crimes imaginable to man. So genocide, crimes against humanity, war crimes, the crime of aggression. These crimes that we call and define international shook the conscience of the world. They threaten fundamental values of the international community, such as security and peace. And therefore, their prosecution can be based on this principle of universality. So even if one single state was not affected in a very direct way by one of these international crimes, it will have a possibility to prosecute the perpetrators, to investigate them and bring them to justice because of the magnitude of the criminal magnitude that is expressed and is actually contained in the very structure of international crimes. So universality, the principle of universality, is a way to adjudicate and prosecute crimes that traditionally would be outside of the jurisdictional reach of national courts and prosecuting agencies.
So the Treaty of Rome is the fundamental international document that brings this together and articulates what it is. Not everybody is a member of the Treaty of Rome. The United States is not a member of the Treaty of Rome.
And I get the fact that there's a lot of differences between the way one country, for example, in Europe, and another country interprets that or legislates that or does judicial gloss on it. So, for example, in the case of a Syrian general who was found within the borders of Germany, they caught him, they tried him, they prosecuted him, and they convicted and punished him. He's in jail now. He wouldn't be sentenced to death because there is no death penalty in Europe. But at the same time, another Syrian general, I think, or a Syrian military person, was captured in France. And in 2021, the French Court de Cassation found against prosecuting him. They said that because the crime involved, which was a war crime, took place in Syria, and that didn't meet the requirements of the French, may I say, bureaucratic standard that you had to have the acts a crime both in the country where it was committed and in France. They found that it just didn't qualify because it was not illegal to do the things this guy was doing in Syria. And therefore, they denied prosecution in that case. Subsequently, only a month ago, they changed their mind about that. And the Cour de Cassation indicated, no, now you could do that. I don't know what happened to the Syrian guy involved, but it just shows you that this is a patchwork around Europe, and different countries have different laws and interpretations, which could be 180 different for a given situation, which is identical. So that's troubling. You got your comments on that?
Yes, it's actually something that follows or flows from the very structure of the ICC and the Rome Statute, that the primary responsibility for prosecuting international crime will lie with the national states. So domestic courts will have precedence in adjudicating international crime cases. This is one of the key and fundamental concepts of the ICC. It's the complementary court. It complements the system of international criminal justice, but it does not supersede. It doesn't supplant national courts. So once again, the primary responsibility for prosecuting international crimes lies with the national states, And the implementation of the Rome Statute differs from state to state. As you said, Germany implemented right after the adoption and the ratification of the Rome Statute Code of International Crimes, the Völkerstrafgesetzbuch. So everything you will find in the Rome Statute, so everything that the ICC is able to apply, you will find reflected, or you will find a national counterpart in German criminal law. Things vary across Europe and across the world. Let's remember the ICC as of now counts 123 state parties, and every one of these parties ratified and implemented the Rome Statute in a different way in its own legal system. If we look at Italy, another example, it's quite a tragedy. As of now, we do not have a crime code on international crimes that actually ratifies and implements one-on-one the Rome Statute. And problems are showing. And if we look at France, we see that there is a way to prosecute international crimes, but a lot of requirements must be met. A lot of limitations are set up in the French law. And eventually, the Supreme Court of France, the Cour de Cassation, had to take a stance and had to modulate the way these requirements are interpreted. And it's actually good news what the Cour de Cassation decided, because now a broader approach will be followed when trying to prosecute international crimes on the national level in France, at least. So you were absolutely right in saying that it's a patchwork when it comes to the implementation of the Rome Statute on the national level. National laws vary to a very high degree, and this is difficult to coordinate between states, and it makes life more difficult even on the ICC level, because again, if we keep in mind that the court is complementary, so national states, national courts take precedence, not knowing what rules will be followed, what the outcome will look like, will just generate uncertainty, and this does not help the interests of international criminal justice as such.
Okay, Tim, that's the background.
Okay.
That's what we got. So what are your thoughts?
Well, my thoughts are, this is all rather confusing because, okay, for example, the United States, we have a set of laws. We follow the Geneva Convention, and that those conventions are usually set aside for recognized prisoners of war that serve in the military. Yet we know back in the Bush administration, Bush Jr., we had Guantanamo Bay and Abu Ghraib, where we didn't classify our prisoners of war, but they were terrorists. And that gave us a new set or a different set of ways to skirt certain laws that we adhere to. Abu Ghraib, I mean, my gosh, they were humiliated, they were waterboarded, and yet the United States basically got a free pass by saying, well, they're not prisoners of war, they're terrorists. So I'm confused on what it takes as far as a definition for people that commit crimes, yet they are able to redefine those that they commit crimes upon, and they get a free pass. And I still think that the United States has some ownership on how we tortured terrorists back in, during that administration.
Federico, let me go back to you for a moment on that. There's a movie that's available now online called The Mauritanian, and it's about an Arab fellow from Mauritania who was detained and transmitted through Germany to the United States, and thus ultimately to Guantanamo, where he spent 14 years trying to convince the American authorities that he had done nothing wrong. At the end of the day, he had done nothing wrong, but he was held in this limbo for 14 years in jail with torture as a way to get his confession. It's a terrible story, but it's a very interesting true fact documentary. My question to you is, given Tim's reaction, and given the whole environment around war crimes and atrocities and so forth, which are happening in the world today as we speak, what is the European view of the United States on this? We seem to be locked up in some kind of political ideological framework that makes it hard for us to actually join the family of nations to seek war crime prosecutions.
Well, it's actually it's a big loss for everyone involved in international criminal justice to see the US, that undeniably is a key player when it comes to international affairs, when it comes to the international community, not joining the ICC, not recognizing the Rome Statute and the values that the Rome Statute actually represents. I think there is always this moral hazard of actually being on board when it comes to the message. There are certain ground rules everyone has to respect, that everyone has to apply. But then seeing yourself on the accused stand changes things up, changes the scenery, because it requires you to take ownership of your past or future actions. And it actually requires you to uphold what you signed, what you recognize as binding international criminal law in this case. So there is close cooperation between Europe, the European Union, and the United States when it comes to diplomacy, when it comes to foreign politics, when it comes to military cooperation. I'm thinking about NATO. But if we take a different stance, and this is the stance of the ICC, of ICL, and again, the ICL is not something that is limited to Europe and the European Union. again, 123 state parties to the Rome Statute. So it's something that has a global nature. Not having a strong ally as the US could be on your side oftentimes feels like a very big loss, and a lost opportunity for both the ICC and the US, because it would send a very clear message that nobody can play the veto card when it comes to international criminal law. So everyone is bound by it, and everyone, irrespective of size, power, economic power, military power, will have to respect the fundamental principles that are laid down in the statute.
So let's talk about fundamental principles for a minute, Stephanie. You know, we have a bunch of prosecutions going on, or at least investigations going on against Mr. Trump right now. And it's taken us a year and a half to actually get around to do something about it. And we haven't yet actually done anything about it from a federal point of view. And so, and that's for, you know, what do you want to call it? Crimes against democracy, and crimes against security, national security. But if you compare that with crimes against humanity and atrocities and genocide and war crimes, those crimes seem so much more important, more immediate in the context of comparison with Donald Trump's crimes. So you wonder where the United States is in supporting the prosecution of people who are mass murderers. And I wonder if you have any thoughts about what the United States should do to show Federico and the EU in general that we care about the prosecution of these crimes against humanity.
Well, I'm not an attorney, of course, but I have been associated with international lawyers and JAGs and people who have been involved in some of these issues, going back to the torture and the treatment of, the Gitmo people, the Guantanamo people. But I think in general, we've been wringing our hands about the fact that we have, is it FISA, Jay? You know, we have got law on the books for international terrorism and crimes of that sort, but we don't have anything comparable here within the country. So there's been a little bit naive on our part, hasn't it? So I think that there's a growing realization that certainly needs to change. But you bring up such an important point, because I know that the United States took but positioning, and the Joint Chiefs were meeting regularly with the attorneys, JAGs, to talk about how to be rational and appear rational to the world in these acts that have been performed, some of which weren't covered by international law, and certainly not by the US's. But I speak of things I know not enough of, just was kind of
okay, well, let me go back to Federico on some of that. You know, it strikes me that a country like the US, which I think is confused on many things and is certainly confused on this, does have some arguments to avoid having the prosecution, the hot light of prosecution, turn on it. For example, there are people in this world who don't like the US and who might use the US's underwriting of war crime prosecution against it, like in Tim's reference to Abu Ghraib. And as a result, you have sort of this international politics going on, which is not necessarily rooted in the universality of the morality and the fundamental principles involved. It may turn out to be just a political adventure. And so what do you say? What do you say to someone who worries about that? What do you say to somebody in the US who says, I don't want to be involved in that. We'll handle Abu Ghraib internally. We'll handle violations of criminal law morality within the military under the Uniform Code of Military Justice. We don't need anybody from outside telling us about this. So you have political, geopolitical, and you have countries in Europe, and maybe France was affected, for example, by the possibility that if they took action, say in 2021 under universal jurisdiction, some country out there, some leader out there, some autocrat out there would be angry with them, and they lose ground in international relations, their own self-interested international relations, and therefore let's back off. It's that back off principle, the failure to join, the moral side of the equation. So how powerful are those arguments?
In my view, they are not that powerful. And my counter argument to this, to the argument you mentioned, we will not join the ICC. We will handle our business internally. That's absolutely fine. And this is actually in the very spirit of the ICC. Again, the ICC is a complementary court. So whenever a state will take action, the ICC will respect this initiating criminal action against perpetrators of international crimes by just standing by not interfering, by recognizing the sovereign right of each and every one of the state parties to handle their own criminal business, let's call it like that, internally. But then again, there is always this one clause in the Rome Statute that the ICC will be complementary and will give precedence to national courts unless they are unable or unwilling to actually take action. And this is actually, I think, the key, the fundamental problem, and maybe the fundamental fear of, let's say, the US, but also other states, other powerful actors on the international level. The fact that the ICC will give precedence to the national courts, but the ICC will not forget about the cases. So you will have the opportunity to adjudicate torture cases, crime against humanity cases, war crime cases. But if you fail to actually prosecute and adjudicate, the ICC will not just turn a blind eye. It will activate its own jurisdiction and start proceeding itself. But it boils down, in my opinion, to taking responsibility under international criminal law. I am state party to the ICC statute, to the Rome Statute. I am able, and I am actually permitted, I am actually encouraged to start national proceedings, criminal proceedings on the national level. But if I fail to do so, someone else will step in. And this is actually the very reason why we need an ICC. It just acts as an impulse giver to handle your business internally, but please handle it. And if you fail to do so, I won't turn a blind eye.
Yeah, but I think if people ought to understand that there's many ways a case can come to the ICC. One way is by reference from the United Nations. And that's kind of been unlikely because the Security Council can veto the reference, the referral of the case. And that means Russia, for example, would clearly veto not only Putin, but any war criminal because it's so close to Putin. So you can't get a reference that way. The other way is by the prosecutor himself or herself. And I suppose that's the only practical way this can happen. And I would remind everyone that before Jack Smith was hired away by Merrick Garland, he was one of the prosecutors in The Hague at the International Court. I'm not sure exactly how far he got with that, but this is the last question I want to ask you, Federico. There's a problem here because we have Ukraine going on our television sets for more than a year. We've seen so much evidence, and yet there's been no reference and to the ICC, and there's been no proceeding that I know of in any member of the Rome Treaty to actually prosecute someone for those war crimes. And if you don't do that, you're sending a message to Putin and others engaged in war crimes that, and we take a long time, and we're not sure what we're going to do here, and we investigate till the cows come home. And the system doesn't work very quickly. So carry on. I think that's the message. Doesn't that concern you?
It does concern me, but actually, Jay, there was some there were some little steps taken. The ICC issued 2 arrest warrants against Vladimir Putin and against a collaborator within the ministry, the Russian Ministry for Family. I don't really remember the name of this one woman that was included in the arrest warrant. And they were both issued, both arrest warrants, by the ICC for alleged war crimes of transferring unlawfully children. So one clear message was given by the ICC. We're watching, we're investigating, we're actually initiating proceedings. And there was always also a very much more general message by the courts and maybe by the international community as such. The fact that even after the war ends, should the war, and we all hope the war will end very soon, after the war ends, there is no space for negotiations with Putin because he is a war criminal. It sends a very clear message issuing an arrest warrant. We have grounds to believe that you committed war crimes, and this means you're not a reliable actor for a post-war scenario. So it already gives some very clear indications to the international community on how to act once the war should end.
Well, Jay, can we ask Federico, is issuing these arrest warrants and expecting people to take responsibility, is that the extent of the powers of the ICC? What other pressures are available to them to try to influence people to step up, or states to step up and take responsibility? Is it toothless?
I wouldn't say that it's toothless. The ICC does not have a police force, an own police force, so it relies on the cooperation of all its state parties. And by issuing arrest warrants, theoretically speaking, all 123 states will be ready to arrest Putin on arrival, or this woman against who this other arrest warrant was issued, and then transfer them to the ICC, to The Hague, for prosecution. So there is a very clear and concrete aspect to the issuing of these 2 arrest warrants. And on the other hand, having an active ICC court also means that there is cooperation on the national level by national states. We are seeing investigations being launched in the Baltic states. We're witnessing investigations happening in Poland, in Germany, in France. People are looking into possible war crimes, alleged war crimes committed in Ukraine. The problem is how to get to those responsible. How do I get them? How do I get them on the French territory? Just to keep with the topic of today's show, in order to arrest them, in order to prosecute them, how do I get to them? But the ICC sends clear messages, and these clear messages are often interpreted by national states as a wake-up call to get involved, to be aware, to be vigilant, and to launch investigations and prosecutions themselves.
Well, is there confidence that states will enact that order to arrest him if he travels to another state? Now, has that been proven that they will follow through on that? Because it would require the state to use its own resources, right? As you say, the ICC has.
That's such a good question, Stephanie.
Can you talk about that possibility?
Yes, ICC history hasn't been kind in this regard. I'm thinking about the al-Bashir case. Head of state, arrest warrant. One of the state parties, South Africa, did not comply when he actually went into South African territory. They did not arrest him and transfer him to The Hague. Now, if we come back to the situation right now, so the arrest warrant against Putin, we already see some cracks in the, one would say, hopefully united front of ICC states, and I'm talking about Hungary. They already expressed some some concerns. Maybe we will not follow through if Putin should ever step foot in Hungary. So it's not a given, let's say it like that. It's not a given, but it's a very clear message to the Russian Federation and its allies that things are moving. People are monitoring what's happening in Ukraine, and states and international criminal justice institutions are actually taking concrete steps towards the prosecution of these crimes that are happening on a daily basis on Ukrainian soil and territory. So there is hope. There is hope, and again, this is a leitmotif of today's show. International criminal justice takes time, and what's important is that steps are taken and that steps keep coming. The taking of steps has momentum and does not just silently vanish.
Mhm. Well, yeah, that trips me to my last question to Tim. Tim, you know, you're very conscious of what the media does or doesn't do. It strikes me that here we are talking about a subject that most people don't know about. They don't know the nuances either. They don't know, you know, the bureaucratic regulations, for example, in France, that still exist before you can actually make the prosecution. They don't know about how it's different from state to state and all the vagaries involved in getting the ICC activated. They don't know. So query, has the media been doing a good job? And secondly, could the media do more? And thirdly, will that have an effect?
Yes, yes, and yes. The bottom line is the media doesn't know its history. And I think those nations that are reluctant to join the ICC or any other organization that persecutes war crimes, they're concerned about their own history. They don't want to necessarily crack open the box of history and to say, we are just as guilty as anybody else in our past. And, you know, the media doesn't necessarily want to go down that rabbit hole as well. So I think it's a lack of knowledge of their own nation's history and the atrocities their own nations have committed. In the case of France, you know, Macron has taken a real hit because he's opened up a can of worms. And, you know, France has its own problems with the Algerian War from the mid 50s to early 60s. You know, there's criticism about what about those atrocities. I guess over 300,000 Tunisians or Algerians were killed. And a lot of it was, unfortunately, involved horrible torture allegations. So could the media do better? Sure. Will it do better? It depends on how much they're willing to go down the rabbit hole of history and bring up these ugly things that makes everyone very uncomfortable.
Stephanie, can you give us your takeaway? We're almost out of time.
Yeah, it seems so. I believe, Federico, that Poland or the other countries that are in the pact of the ICC, they need to consider whether their enactment of that obligation to the ICC would result in Russia seeing it as an act of war. So that actually might, I'm saying actually, I'm asking you, is that a possibility that the Russians might interpret that as an act of war and move it to the next level, move the conflict to the next level?
First of all, I doubt that Putin will ever leave the territory of the Russian Federation in the foreseeable future, if ever. Second of all, let's always be very conscious about the Russian strategy of always escalating, at least in the discourse, the possible consequences of any kind of action the West takes in relation to Ukraine. It's always an issue of watch out what you do next. We have nuclear weapons. This could escalate in a full-blown nuclear war. Watch out, we will send in the special troops if you do this and that. Watch out if you send any other military aid. We will escalate all kinds of military operations in Ukraine. And in part, they do escalate. the situation. Let's just think about the recent attack on the electricity dam in Ukraine and the southeastern part of Ukraine. But again, it's always a question of do we let this kind of threat slide as the international community, as the democratic and freedom-loving, I would say, international part of the international community? And I would say no, we cannot actually budge in front of these kinds of threats. And please allow me just to cite something in Latin, which is something that is widespread all across the world. This phrase, "Si vis pacem, para bellum," if you seek peace, prepare for war. I would like to just turn it on its head and change the last part of this phrase with "si vis pacem, para justitiam." So if you seek peace, prepare justice. And this is something that I think we should always keep in mind. We cannot continue to imagine a future of the international community which entails wars as a means to actually carry out diplomatic grievances, and war as a means to start a conflict, and always as a means to end it. We need to focus on justice, on international criminal justice, as a way to ensure the fair adjudication of what's happening on the international level, and as a way to ward off any future dictators that think that they can get away with horrendous international crimes by making threats, by escalating violence, and by hoping that the international community and international criminal justice institution will turn a blind eye because they are afraid, because they feel threatened. So again, I feel that it would be a good mental approach to the situation in Ukraine, that you will have peace only with justice, and justice not only in the criminal sense, but also in the sense of a just peace, of a just peace treaty, of a fair peace treaty, which cannot be something that is decided by the Russians and is just accepted without any kind of reservations by the Ukrainians and the West or the international community as such.
Thank you, Federico. Federico Thofern, Tim Apicella, Stephanie Stoll Dalton. Thank you for a very important discussion. Aloha.